Hello and welcome. This is the first of our series of discussions with key participants in the EU's processes of creating, monitoring and changing European-level legislation and regulatory initiatives in the financial services sector. My name is John Barrett and I am a member of the European Regulatory Interest Group of the CISI. But our guest today is Dr. Emil Paulis, Director of the Capital Markets Division of the European Commission's Internal Markets Directorate. Dr. Paulis is a long-standing public servant in the European Commission. He has Belgian nationality and understands very well the role and position of the Commission in the EU processes. He is an ideal candidate for the CISI's first webcast on European themes. And Dr. Paulis, with that introduction, I wonder if I could ask you, what is the European Commission's role in EU financial legislation and regulation?
Yeah. Thank you very much. The European Commission has been in the center of all the reform work which has been going on over the last 5 years since the beginning of the crisis. The role of the Commission is not always very visible from the outside, but it is central because it is holding the right of initiative of legislative proposals. So if at European level we want to do something, if we want to reform, if we want to change something, then the proposal has to come from the Commission. So it has an initiative right which no other institution has.
Can I just interrupt? That is a right by law.
That's a right by law. It is difficult for Americans, for instance, to understand how it comes that an executive, the European Commission is an executive, how the European Commission can have a monopoly of legislative proposals. One word on that, it's very easy. It is because the European Union is not completed, and therefore we have a phase of building up the European Union where small and big member states are involved. And it is considered that the small member states in particular can only trust that the whole process of building Europe is done in a community spirit if there's a community institution which makes a proposal. And that's why the Commission is there. You see, the Commission was created and was given this monopoly of initiative for that reason. So during these 5 years, the Commission therefore has made a number of legislative proposals which then go to the legislator. The European Commission does not have the power to adopt legislation. So it's the legislator, which is composed of the European Council, 28 member states now, and the European Parliament, who have the power, and only them have the power to make it legislation.
Could I just ask that question here, that when you make your proposals for legislation, they are to the European Council and to the European Parliament,
yeah.
And it's for this reason you're actually proposing to them draft legislation which they then consider as the key legislators.
Yes. And it goes with this monopoly of initiative, the right, therefore, to also withdraw a proposal. So if a proposal by the Commission is what we call in Franco language, dénaturé, denaturalized, so to speak. It's deviated from its purpose. It's deviated from the community interest purpose. Then the Commission has the power to withdraw the proposal and therefore to stop the whole process, to avoid the adoption of legislation which would not be in the broader community interest. Another consequence of this monopoly is, and it's very important to understand, is that when the process is ongoing, the process of discussion in the Council and in the Parliament, between the Council and the Parliament by way of reconciliation of positions, the Commission is always around the table. And if the Council wants to adopt a legislative proposal which contains amendments to the proposal of the Commission, it can only do so by unanimity. So normally the rule is majority vote, but when it deviates from what the Commission has proposed, because the Commission is assumed to have proposed a community interest community interest initiative, then they have to switch to a higher standard, which is unanimity, to overcome the opposition of the Commission. And even in that case, the Commission can withdraw the proposal to block the whole process. So it is quite a process where the Commission fully participates in the process of legislation.
And in this process is the use of the withdrawal, the the blocking of the process, is that very common by the Commission, or is that more of a rarity that occurs only in certain cases?
It's very rare. And it has to be like that, because the Commission is not the legislator. So normally it does refer and gives, of course, deference, full deference to the legislator. It would only be in extreme cases where the Commission as a college would consider that there's a real problem, a real contradiction, so to speak, with the community interest, that it would then withdraw. It has happened. But the fact that it happens very rarely has a merit, you see, and that is that this is not something which the Commission uses in an abusive way. It uses it only where it is really justified to do so. And that is the weight, of course, which stands behind it.
How does the Commission decide between directive and regulation? What are the criteria? What accountability is there? Who assesses whether the decision is well-founded?
Yeah. So the key difference between a regulation and a directive is that a regulation is directly applicable towards companies or individuals in a member state. A directive is not addressed to individuals or companies. A directive is addressed to the member states and requests and requires the member states to adopt their national legislation which transposes the obligations contained in the European directive. So we have one instrument which is a regulation which creates directly applicable law, and we have another instrument which requires a transposition via national law. How do we choose between the two? We choose between the two in function of the interaction between the community rules and national rules. If this interlinkage is a difficult one and requires a lot of adaptations at national level, then we would give more leeway to the member states and we would proceed by way of directive. If it is an area of competence where you can create fully fledged out substantive rules which can be directly applicable without any further application of national law, then we normally go for regulation. That's the general picture. In the financial area, there are two things which have happened. First of all, the Council, at the very beginning of the Council, has said we need to create a real single rule book. And in order to create a real single rule book, you better proceed by way of regulations and directive, because you imagine that if we send a directive to the member states, then there is the phenomenon of what is called gold plating. That's to say, you don't get the same transposition in 27 member states. You get divergences. And that is then giving way to a lot of disapplications, exemptions, and all kinds of excuses not to apply community law.
This is called national discretion, I think.
National discretion. So basically, therefore, in the financial area, the Council has asked us to proceed by regulation as much as we can in order to create a true single rule book, a true book where everybody applies the same rule. All the judges in the 28 member states apply the same rule. That's the first thing. The second thing which is taken into account is, of course, the treaty, because the treaty gives us the legal basis to act or not to act. And the treaty also provides whether we can proceed by way of regulation or by way of directive. And that is something which sometimes gives due to discussions between the Commission and the Council and the Parliament. For instance, now we have a discussion ongoing on our proposal on the single resolution mechanism, where some people say that the regulation is not the best way, or this or that, you see. So you can get that kind of debate, you see. Who is going to decide on who is right and who is wrong? In the end, first of all, the legislator, because the legislator will decide whether he does it in form of regulation or directive. And then each member state has the right, and sometimes individuals as well, has the right to attack the legal base before the Court of Justice, and ultimately it is our European Court of Justice which decides whether we got it right or wrong.
Before we leave this subject, I'd just like to ask one final question about that particular issue, the regulation and directive distinction. As you have said, the directive effectively goes through a national parliament of a member state,
yes,
and gets implemented according to the national arrangements under that legislature. The regulation goes from the Commission, once agreed and finalised, of course, through the European Parliament, which we'll come on to. It goes from the Commission to the European security authorities. The relevant one in our case is often ESMA, because of the capital markets arrangement. That is the European Securities and Markets Authority. They then implement for Europe as a whole. There has been some criticism of this, that this has over-centralised the process of European legislation and taken it away from the member states. Do you have a comment on that, or is that something that you feel is not such a concern as people say?
I think that is a misunderstanding, because in fact what has happened is that there was a massive delegation of rule-setting power from the Commission to the ESAs, to the new European supervisory authorities, the ESAs. And the ESAs are composed of the national supervisors in what is called a board of supervisors. And I sit there with them as a representative of the Commission. And it is the national supervisors who bring in their national experiences, discuss them amongst themselves, and then decide first amongst themselves which way they want to formulate the rules. They then send these rules to the Commission, and the Commission then normally endorses them. We can come back to that, go a little bit more into that, you see. So in fact, the process is really a bottom-up, you see, but with the benefit that there's an interaction, a discussion, a dialogue between the national supervisors, which then leads to a common single rule book. And one more point. The ESAs, when they develop rules and send them to the Commission can only implement them by way of regulation, never by directive. So that's foreseen in the regulation which has set up the ESAs. So it is a regulation, and that is the consequence of this decision of the Council, conscious decision of the Council to create a true single rule book.
What is the Commission's relationship with the European Council and the European Parliament in developing new financial law and regulation? How is this managed?
That always surprises me, because in fact, when you compare with the way we proceed here in Europe with the US, we are a glass house. Everything is known the minute it comes out of the mouth of somebody. So the way it goes is that when we make a proposal, it is sent to the Council and to the European Parliament. Each institution then starts its work. In the Council, they set up a working group, which then brings together the 28 member states, and the Commission is also sitting around the table, and they discuss article after article the proposal. The European Parliament does a similar thing. The European Parliament sets up a rapporteur and shadow rapporteurs and then discusses it in the Econ committee, or whatever committee it is, could be another committee, and then they come also to a kind of preliminary conclusion, you see. And then when that has happened, the two compare the two drafts and sit together in what is called a trilogue meeting. And in a trilogue meeting, it is a trilogue meeting because the Council, the Parliament, and the European Commission, which are sitting there with a lot of experts, of course. And in that place, there is a discussion about how can we bring the positions together. There are plenty of opportunities for everybody to know exactly what is being done there. There are plenty of opportunities for everybody to come in and bring its input to it, not of course directly around the table, but by feeding it into the one or other MEP or the one or other member state, or coming to see the Commission. Many, many times when a trilogue is going on, I have stakeholders coming to my office here and coming with concrete proposals suggesting that the Commission should change its original proposal. The Commission can and does regularly, in the course of the process, we have a procedure for that, regularly and can and does regularly amend its own proposal. Because remember, if the Commission does not change its proposal, then the Council could only act by unanimity. And we don't want to provoke that. We don't want to raise the bar unnecessarily at that high level. So as we go through the process, the Commission then comes forward and says, okay, I propose that we make a change of 61 in the following way. And that is a proposal by the Commission.
That's extremely interesting. Again, I think that not many people know that the Commission does change its proposals quite a lot once it's gone through its own initial processes. Just the point you raised there also, the point about experts or indeed members of the public or representatives of those people coming to see you during the trialogue process. This raises the issue of the participation of the public and the industry and their representatives in the process as a whole. Would you like to give us a little comment, please, on how that works? Because, of course, it's very important in terms of transparency that the wider stakeholder groups also can be involved.
Yeah, this is absolutely essential that the whole process, starting with the Commission, but also in the Council and the Parliament, remains an open process. We must be an administration, we must be a government, so to speak, which is open to the stakeholders. And therefore the stakeholders are all welcome to see the Commission, to see the Council, to see the MEPs. There's nothing wrong with that, you see. We need to have many contributions. So it is the diversity, the multiplicity of inputs which we get from different sides, from the supply side, from the demand side, that makes it that we can then balance the different contributions and make up our own view and then possibly amend our proposal or even change it before we make the proposal. There are two things, however, which need to be borne in mind, and that is that this process can only work if you have a strong Commission. The Commission should not and cannot fall into the trap of being influenced by one particular type of lobbying and ignore another type of lobbying. And therefore you need a strong Commission. There's another requirement for this to work, and that is transparency. As you mentioned yourself, you see, we need to be as transparent. That's why we proceed very often by consultation papers, call of evidence. We have to make an impact assessment of costs and benefits of our proposals, which is made public. We have to be accountable to the Council and the Parliament. Our Commissioner, for instance, Michel Barnier, goes regularly to the European Parliament, to the ECON, to explain why he has made this or that proposal or why he is changing position on this or that point. So there's a constant flow of accounting to the legislator arm in the whole process. So all these conditions, strong Commission, transparency, accountability is part of it. Now, I can understand that seen from the outside, it looks all very complicated, very opaque, not very democratic, but believe me, these matters are not easy, and you need to discuss them in smaller groups. But these smaller groups should not be closed groups. They should stay open. They must be open. They must be challengeable, and they must be challenged by the stakeholders. And that is what is happening. I can testify really on the ground. It is happening all the time. All the time. We get stakeholder inputs all the time.
What are the political influences on the Commission in preparing legislation and managing its passage? Does the Parliament or do individual MEPs seek to exert influence? What are the effects of external influences, such as member state governments, major regional or global events, or third countries?
Now, this is a very good question, and let me say the following. We live in a capitalist society, and happily so, because a capitalist society is driven by self-interest. And therefore it is quite normal that people come as a stakeholder to defend their point of view. And it is absolutely normal as well that individual MEPs speak to my commissioner, that individual member states write letters to the Commission, to the President, Mr. Barroso, or to my commissioner or other commissioners. All that, I think, is the real world. You cannot imagine a world without that. And it is good that it is like that, because we are in that kind of process of finding a solution through the input of many, many stakeholders. So, how does the Commissioner deal with that? The Commissioner gets involved, of course, mainly in the political aspects of a file. He does not, it's not really the role of the Commissioner to put his hand down to the last detail. That's why he has a department headed by Jonathan Fall here. So he relies on the input from his department. He gets the political input and influence from various stakeholders, and then he of course drives the whole process. He tells his department what to do, how to react to particular positions which are taken in the Parliament or in the Council, and we of course as an administration execute these instructions very, very, very thoroughly. So that's a normal process, and I think it works very well on condition that you have, again, a strong Commission and strong commissioners.
Thank you very much for that little political discourse there. Could I actually now go back to what we said we would come back to, which is your relationship to the European supervisory authorities? These are very important in the new structure of regulation in Europe. We will not go into the detail of how they were formed particularly, but just to remind our audience, they started in January 2011, so they're actually very recent. It's a new initiative in the European Union as a whole to develop this method of regulation. You've mentioned already your relationship to them in certain contexts, but the actual structure of the law as it comes out after your trialogue process and the way in which they participate in the secondary development is important. You have what we often have called level 2 implementing regulations. You have to seek, you're obliged to request advice from them. You are not obliged to take their advice.
Yep.
And you have also under the regulation process, as opposed to directive, under that regulation process there are the regulatory technical standards that they have to draft in relation to what is produced out of your parliamentary council and commission work on the legislature. So could you talk a little bit about this level 2, this secondary level legislation, how you think about that and how that works in terms of influencing the markets?
Yeah. Okay. To well understand this, compared to what existed before. Before it was level 1, the Council and the Parliament, which put out the principal legislation, and then they delegated the power of implementing legislation to the Commission. And the Commission would do itself the formulation of that policy. Now there has been a massive delegation of that rule-setting power to the ESAs. The ESAs do not have the power to make these rules binding, but they have the exclusive power basically to develop the rules, and then they send them to the Commission for endorsement. The Commission then retains an autonomous power, which is either to endorse tel quel, as we say in French, as such, or to endorse them only partly or with amendments. But if the Commission refuses to endorse them tel quel as such, then it has to send them back first to the ESAs, which shows the power which has been given to the ESAs, who then have another chance to reformulate their rules, send them back to the Commission, and then only in the second round the Commission has the power to deviate from what the ESAs have proposed. The Commission, when it wants to deviate from what the ESAs have proposed, has to justify, has to give reasons why it deviates from what the ESAs have proposed. It has to give these reasons to the Council, and it has to give these reasons to the Parliament, because in the whole process, the Council and the Parliament keep the power to object to what the Commission does. So if people, for instance, say that what the Commission does is not democratically legitimized, but just take account of the fact that whatever the Commission does by way of delegated power from the Council and Parliament is subject to the ultimate power of the Council and Parliament to say, no, what the Commission did is not what we wanted to do, and therefore it can object. And the Council and the Parliament ultimately are legitimate democratic institutions. They have been.
May I intervene there, just ask, and have you had examples of objection from the Parliament and Council?
Not yet.
It's quite new, the whole system, I understand that. But not
yet. It's quite new. And how do we work with the ESAs? Of course, we are by law entitled to be an observer in all the meetings which the ESAs hold on the rule-setting process. So, for instance, I represent the Commission with Jonathan Fall and Nadia Calvino in the Board of Supervisors. So there's always a representative of the Commission. I also represent the Commission in the Management Board of the ESA, in this case ESMA. So we follow the works of the ESAs. And the ESAs create also task forces where they then have specialists, experts who work out the particular rules. And there again, there's a close cooperation between the Commission services and the ESA services. So it is a process in which we can, in the course of the working out of the rules, we can already signal to the ESAs that there is likely or not likely to be any problem. When can there be a problem? Yeah, there can be a problem when the ESAs would do something which would violate existing community law, so or level 1 or level 2 existing law, which is already on the books, or where they would do something which would fly in the face of what is the true community interest. And for that, the Commission is the best placed institution to judge what is community interest, subject to the control of the Court of Justice. So that is the mechanism. So in essence, there is only a narrow scope for the Commission not to endorse. So that means a massive delegation of power has taken place to the ESAs.
And in this delegation, do you retain an oversight role, not so much on the substance of what they do, which is what you've just spoken about, but on the actual management side? If you feel, for example, the ACEs are not acting competently, or whether if they are not in some way managing their affairs well, if there are complaints about the ACEs, do you have a role in supervision, in correcting this situation, or advising them, perhaps obviously quietly behind the scenes, because we wouldn't expect it to be a public issue, to put their house in order in any way?
Yeah. The ESAs have been created on purpose to be, on substance, really independent agencies. So the Commission, although we are the supervising authority, we are supervising authority from an administrative point of view. So from a management point of view, we advise ESAs to do particular things, but they are free to decide the opposite, you see, and subject to respecting the law, of course. The budget of the ESAs at the moment is partly financed by member states, partly financed by the community budget, but most other agencies from the community empire, so to speak, if I may say so, are 100% financed by the community budget, and that is no problem at all in terms of keeping the independence of the agencies. These are matters which are dealt with completely separately. So it's not like in other parts of the world, you can think of which parts, where there's a direct link which is being made between the financing and the positions taken on substance. We don't know that here. There's never any link between the two, never has been, and I can really testify of that. I've managed it here from this side. There's no connection between the two whatsoever in our system.
I think these points of structure are very important, actually. It's important that they're understood by those who are operating in this field. And could I just take this point of structure one step further? One of the things you are, if you like, overseeing and in fact developing yourselves is the review of the supervisory structure we now have. And that was mandated by the law that set it up in the first place. Your 3-year limit.
Exactly.
That. The supervisory review, many agencies have been I think responding to your questionnaire on this, and you'll be no doubt evaluating all this over the summer months and so on. Can I ask how you regard the supervisory review? I mean, do you have a preferred outcome? Is there some area, some way rather you would like to see this develop, or do you just wait for the evidence? And also, many people have suggested that this is a Trojan horse, if you like, for structural change, so that you will actually perhaps even get to a situation where you want to, or you are mandated to terminate the structure of 3 ESAs that we now have and develop kind of twin peaks, as people call it, or even a single supervisor. Twin peaks, I think people suggest, will be based in Paris and Frankfurt. There will cause some issues with people in London, I think. And also a single supervisor in Brussels. It may meet the issue of the Twin Peaks problem, but then, of course, it would be a very centralized piece of institutional architecture, which wouldn't be favorable to lots of people. So you have a supervisory review, an outcome which you might prefer, and then this issue of structure. How do you answer those things?
Many questions in one question there. But indeed, it is true that we are fully engaged now in what is called the review of this architecture of supervision, which we have created in Europe. And the Commission is bound to present its report by the end of this year. We have held already a conference here in Brussels, where all the stakeholders came together, where we have heard what they said about it. I can say, grosso modo, globally speaking, there was quite some satisfaction about the way it has been running so far. There were a little bit more criticism of the ESRB, but not so much of the ESAs. But that is not to say that there are not many things which can be improved. Does the Commission have a position at this moment? I can sincerely say no. It's too early because we have not yet reached that stage. And by the way, this Commission will make a report and will probably leave it to the next Commission to make any proposal.
Could I just comment on that to our audience? The current Commission, it finishes in the summer of 2014 and has to be changed by law with new commissions. I think
yes. In fact, the exact dates are that in May we will have the elections of the European Parliament, and then Following that, the European Commission in October, begin November, will change. So there will be a new Commission in the autumn of 2014. So it is most likely that this Commission will no longer make the proposal of how to restructure and improve the existing architecture of ESAs. So at the moment, the Commission does not have a particular position. We are making this report. But of course, time will come where the Commission will have to have a position. And all the issues which you have mentioned, how many ESAs there should be? Should there only be one? Should there be two instead of three? Where should be the seat of these ESAs? Will inevitably be part of the discussion. I would say that it is tempting to compare what exists at a member state level with what you would like to have at European level. But Europe is more complicated. And for instance, we have now created the single supervisory mechanism, which gives the supervisory power for a lot of banks to the ECB. That has already an impact on how EBA will look in the future. There is a twin peak system debate, which will inevitably come. There is the issue of the insurance supervisor. You know that it would not be possible by the present treaty to grant any powers to the ECB over insurance companies. So the situation is a little bit more complicated than you would find in a typical member state scenario. So that can, of course, have consequences on how the architecture will look like then in the future. But I would say that it is absolutely expected that the powers of the ESA should be further strengthened, and that will touch upon issues like the composition of the Board of Supervisors, the composition of the Management Board, the power of the chairman of the ESAs, and the division of powers, for instance, between EBA and the SSM, the Single Supervisory Mechanism, incorporated by the ECB. So all these issues are on the table, and they will certainly be leading to sui generis, as we say, a sui generis structure of Europe which is fit for purpose. You can look over the pond in the US. Look how many agencies they have over there, you see. It's not easy over there either, you see. So it is part of a bigger entity like the European Union, 500 million of people and more soon, that you need to adjust precisely to the... And then the seat, I mean, I personally, but now I speak not for the Commission, I personally think that we should have more agencies and bodies located in different member states. Why? Because people need to see the physical presence of European institutions to get trust built up in European institutions. If my wife is for 6 months in the States and I ring her every day and say, I love you, after 6 months, it sounds a little bit creux, you see, as we say in French, a little bit empty, you see. So far from sight, far from heart, you see. And the same with people, with institutions. If they don't see the institutions, if they can't walk into the door, you see, then it's very difficult for people to trust the institution. It's very, very difficult for the European Commission, for instance, to communicate all we are doing here from the center in Brussels to 500 million of people spread over such a wide territory. And therefore I think it is not a bad thing, and that's what we did. We didn't propose any agency to have a seat in Brussels. We proposed deliberately London, huge financial center, 80% of our financial center in Europe, Frankfurt and Paris, you see. So that made sense, and I think that is what should guide us.
What about structural change? Does the Commission have a view on the Twin Peaks proposals, which would probably leave regulators in Frankfurt and Paris, or even a single supervisor in Brussels or Frankfurt? What about the problem of leaving the EU's major financial centre, London, out in the cold? Isn't this a bit like leaving New York to one side in financial policy considerations in the USA?
Yes, I can say two things on that. First of all, I've been for a long time in this house. I have never found anybody in this house who would have displayed a kind of anti-UK position. Here in this House, in the European Commission, we don't know nationalities. Whether you are from the UK, whether you are from Belgium, whether you are from Germany, I work with my colleagues and they work amongst themselves as if they are all brothers and sisters. Point number one. Point number two, I think the UK is absolutely essential to stay in the European Union. It is a huge added value that the UK is in the European Union. Why? Because it is, from our perspective, from the non-UK perspective, you may say, it is the Anglo-Saxon philosophy and world which is brought in by the UK. We need this. And it is the combination of the Anglo-Saxon culture with the typical civil continental culture which can result in the best outcome, in the best breed, so to speak, when you look for solutions. And we are in a globalized world. And we have the advantage of having in Europe this diversity of cultures. So if we were to lose the UK, if the UK was to leave the Union, this would be an impoverishment of the European Union. So that is seen from our side. From the UK side, I think it must be very important for them to stay in this big enterprise. You can choose in life. Either you live in a house by yourself and you put up your British flag, you see, and then you try to attract as much attention as you can. Or you choose to live in a much bigger house, which is much more visible from further on, you see, with many flags, where the British flag can also be out, but where on the top there's a European flag, and where you can benefit from the synergies of this huge, huge market which we have. Look at capital markets. I mean, Hong Kong, Singapore, the US, they are all highly interested to come and invest here, to have access to our investors, not just to London, not just to the UK. However important the UK financial center is, it's hugely important, and it will even become more important if it stays within the Union than if it leaves. So I pray God, I speak from my heart here, that the UK will never leave the European Union. And this, I think, is good for the European Union, it's good for the UK, it's good for England, it's good for Scotland, it's good for the Northern Ireland, it's good for all of us. So I pray God that this should never happen. Oh, Wales as well, sorry. Forgive me, also Wales should forgive me.
Before we close our discussion, could I just ask a couple of points? You have already mentioned the single supervisory mechanism. I don't think there's any need to explore this a lot further. But could you just give a little bit of information to our audience about how the Commission sees the impact that might make on existing structures? It is, after all, a mechanism set within the European Central Bank and will relate initially to Eurozone nations only, and other people can sign on, of course, if they wish. How do you see that slight disjuncture between the Eurozone, on the one hand, having a single regulator, a single supervisor, for the banking sector, and the others? That's the first thing. And secondly, do you see an evolution of this coming forward?
Yeah. Okay. Let me put this into perspective. First of all, I think what we need to realize is that for the last 40 years we have lived in a community of benefits. We have had the benefit of free movement of capital, people, goods, everything. These were the benefits of the internal market. Now has come the crisis. And with the crisis we realize, we have to share a burden. And it is so difficult. A family can gotten broken up, you see, if there are financial difficulties in a family, you see. So it's so difficult for the more rich nations to share with the poorer nations and help them to come up, you see, to a higher level. So we shift from a community of benefits to a community of burden. I explain this why. Because when in a family brothers and sisters have to share a burden, usually they can't agree. You need parents to make them agree. And what are we doing with a single supervisory mechanism, with the ECB? We are moving away from the national territory, the supervision of an essential element for the function of our economy, which are the banks. They must be in good health for growth to come back. And
that is not in dispute, I think.
No, not in dispute. So in order for this burden sharing to be alleviated, the only ultimate solution is to give the power of supervision to a community institution. The ECB is a community institution. That's the first consideration which was behind that move. So that's the whole idea of the banking union. The second idea is, of course, that national supervisors, they are sometimes biased by their own national environment and don't see where things go wrong for the national institutions. And therefore it was absolutely necessary to lift also from a supervisory point of view, so not only from a burden sharing point of view, but also from a supervisory point of view, to lift it up to an arbiter who is above the member states. These are the two fundamental reasons why we created the SSM, so the single supervisor mechanism. Now, what is the impact going to be? The impact is going to be that the whole dynamic of burden sharing, the dynamic of supervision will be changed. And if it is going to be a success, then it will have the impact that other member states who are not yet in the Eurozone will feel encouraged to join that system, because it should lead to a better supervisory system and therefore to healthier banks, to stronger banks, and therefore to better growth. Now, is it a problem? Is London left out in the cold? No, because while we lift the supervision up to the European level, we keep the same rules for everybody, single rule book, so that we make the link between the foundations of the functioning of the internal market, which must be the same for all of them. There's no distortion of competition, no discrimination between the member states, no discrimination between the banks. So those things, they are given. So that is there. That therefore continues to apply to London as well. But the supervision of a number of member states who are in the Eurozone will be given in the hands of a European institution. It will make it better. It should make it better, and therefore also better for London. So it's not a question of leaving London out in the cold. And we put EBA in London. EBA is in London, you see. It's a recognition of the importance of the financial center of London. EBA will continue to be very important because it will continue to develop the implementing rules in the field of banking. So this is an important signal to London that we want London to shine and not to lose out in this whole game.
One final question before we close. This is really to do, again, I think, with your broader stakeholding community and the role of the public and the industry as a whole in the process which you've been so kindly describing to us. I think that you gave an answer to this already in an earlier part of this discussion, but I'd just like to say, do you feel that the Commission has, in a way, I think, for many who have been engaged in European processes over the years, has actually become increasingly transparent, increasingly open, actually, to discussion and interplay with the broader stakeholding community? Do you see this as continuing? Is this going to be vital for the Commission's future? Is this something that will be a sine qua non, if you like, the continuing existence of the Commission structure as a whole as it currently is?
Oh, it is, absolutely, absolutely. We need to stay an open house. We need to discuss on a permanent basis with our stakeholders. We need to be really a defender of European interest. We need to become more American in that sense. Not anti-American, but more American is a nuance. We need to see the interest of Europe as a bloc in the global market, Asia, Europe, the US. So the Commission could only do a job which is at the service of its citizens if it is in tune, if it is listening. The thing which we, of course, experience here is that we have a lot of input from the supply side and far too little from the demand side.
I think we must endorse that. This is something which is universally thought.
Yes.
Maybe quite nice.
Yes. And this gives me perhaps also an opportunity to say then a last word about that, and that is that I think when people talk about democracy in the face of the rule setting, they say very easily, yes, but where are the elected people? They are there. The European Parliament is elected, you see. But what people forget is that you need more than democracy at the level of rule setting. You need before all, democracy at the level of law enforcement. And that means you need easy access to justice, so that the man in the street can go to the judge and get reward, get compensation for harm done to the investor, to the consumer, in an effective, rapid way. If it doesn't, then it's no good in having rules. Then this nice talk about democracy, about rule setting, is to some extent vanity. Because if I can't get enforcement in court, which is efficient, not too costly and quick, then there's no justice which is being done. And there, Europe has a lot to do. The US is far ahead of us, you see. We have a system of judicial redress which is slow, which is very often very costly, and which does not easily allow the bundling of claims. And because we don't easily allow the bundling of claims, too many claims are too small to be brought in court. But they still mean a lot to the individual person who suffers the harm. So we must do something to considerably improve what I call the judicial democracy. Access to justice, very important. So everything which we can do in that field from the Commission side is certainly, the Commission has just made a proposal which is being debated in the Council on collective redress. That is very important. That should be pushed as far as possible to create effective redress. Because all these people who have suffered in this crisis, how many in Europe have effectively been compensated for the harm which they suffered? Far less than in the US, and that is not right. That means that people can get away with it. That means that people can cheat the system and do not have to pay for the harm. And that is something. So you have to invest not only in rule setting, but also in the effective enforcement, speaks the judiciary. The other last point, and that's really the last point, and that is about resources. I know that outside, and here, of course, I have my ears very, very much open to all this kind of criticism. There's an army of bureaucrats here in Brussels. Do you know that for all this work on financial reforms, for the many proposals which we have made over the last 5 years, we have exactly 190 officials to do that?
It's much smaller than this you would think.
190 officials. I have the exact figures. So I'm not pretending anything here. These are the precise data.
That's for the whole of Europe?
For the whole of Europe. We have in this whole DG for the internal market, which covers every sector, we have something like 500, 550, 600 people, not more. For the whole of the Commission in Brussels, people speak about it now, we have only 21,500 people, of which many people are translators and interpreters. Only 10,500 are what we call AD officials. That's to say, people who do the conceptual work, and including interpreters and translators, you see. So this is the reality, you see. I'm not complaining. I'm not asking for the Commission more resources. I understand the environment. But just to put in perspective, so that people get a real grasp of what they are speaking about.
Dr. Emil Paulitz, thank you very much for your views and for your explanations to our audience. I hope they find it very interesting. Thank you very much for your time.
Thank you.